Okay, I think everything should be on. Is there anyone at the main jail? There we go. Hi, good afternoon.
Good afternoon, Judge.
How are you?
I'm good. Just trying to get settled.
Okay, do you need a minute? Pardon?
Please.
Okay, we'll give you just a minute. Okay.
1 minute. Thank you. That opportunity?
Okay. All right, then we're on the record here this afternoon. Good afternoon, everybody. If you're here this afternoon for a first appearance in front of me, I'm going to advise you what the charges are, let you know whether or not I find probable cause, and determine what, if any, bond amount has been set or will be set on your case. So when I call your name, I'm going to ask you to step forward, please. The first one I have is Antonio DeMarco. Okay, so I don't need to take any action on this case. Okay, thank you. The next one then is Beatrice Jean-Pierre.
Ms. Jean-Pierre,
Downtown.
she is approaching.
Oh, she's downtown.
Good afternoon, Ms. Jean-Pierre. You're here this afternoon charged with neglect of a child without great bodily harm. I do find probable cause. Bond was previously set by Judge Usan in the amount of $10,000.
Judge, if I may, and speaking Ms. Jean-Pierre, obviously she can't afford the convenience bond is what she advised me. That's why she's still here in custody. My understanding is the date of this alleged incident was a couple weeks ago. The children were removed. They're no longer in her care. I believe they're with the natural or the birth father. Right now, Ms. Jean-Pierre advised me she's not working. She basically likes food stamps. She lives in Sunrise. She just moved into an apartment about 1 month ago. Her rent is approximately $700 per month. She does receive some child support. 39 years old, been here over 30 years. What I would be asking the court to consider is to reduce her bond from $10,000 to $1,000, Judge.
State, I hear from you.
Yes, Your Honor, I'm going to be requesting that the bond be kept at $10,000, and that the court order no victim contact, and that she surrender her passport prior to her release. Your Honor, Ms. Romero states, when this took place. Part of the dates of these incidents is because Ms. Jean-Pierre left the country to go to Haiti, leaving her children behind. And I don't really need to go into details. The court saw the affidavit.
I have read the probable cause affidavit.
And they're very clear.
The affidavit.
I think these are extremely serious allegations, Your Honor, and I would ask the court to keep the bond that Judge Usan set in place.
I am going to leave the bond in the amount of $10,000. I do find probable cause.
Yes, sir.
And Your Honor, as far
and
as...
I do, if she is able to make the bond, she must surrender her passport.
Your Honor, just so I know for the order, is that prior to release?
Prior to release.
And again, I apologize, Your Honor, as far as contact, victim contact.
Well, I'm not going to address that today. I mean, looks like there's other matters that are pending that'll probably address that issue.
Yes, ma'am.
On another day. Tamora Rashonda Miller.
Ms. Miller's here present. Come on up, ma'am.
Patrick Lawson.
Ms. Miller, good afternoon. You're charged with grand theft, also fraudulent uttering of a false instrument. I do find probable cause as to each of those offenses. Bond was set in the amount of $1,000 on each count for a total of $2,000.
In speaking Ms. Miller, she did give me the phone number of family. I intend on calling them after court and having them post their bond.
Okay. We have Mr. Joseph
She is currently in transit, Your Honor.
in transit
She's
from,
going from the main jail to Pompano, I believe.
We could just put on recall, Judge.
okay, we put it on recall then. Daisy Marie Van Hoosen.
She's approaching, Judge.
Good afternoon.
Good afternoon. Ms. Van Hoosen's here this afternoon on one count of loitering and prowling and a probation violation from out of the county, Hendry County hold. I do find probable cause. What says you with regard to the, would you like to resolve the loitering and prowling?
No, Judge, I'm going to advise her not to. What I'm going to ask the court to consider doing is ROR so Henry County can come and pick her up. I know there's a 948 hold on the count number 2, so that's what I'd be asking for, an ROR, so she can address her felony violation probation.
All right, the state having no objection, I'm going to release her on her own recognizance on the loitering and prowling. Ms. Van Hoosen, that case will still be pending here, so you will need to address it, you understand?
That's fine.
Okay.
Thank you, Judge.
Robert Thomas.
He's approaching, Judge. My understanding, what's here on the regular docket is a municipal ordinance. Mr. McLaurin's here, but he's also on the second look docket, and those are state offenses. So if we can address both matters at this time, Judge.
Okay, on the second look docket,
46.
I have him on a second look on case number 1812368 CF10A, which is a burglary of an unoccupied structure and burglary of an unoccupied conveyance where the bonds are set in the amount of $1,000. So with regard to the capias, the municipal ordinance, there's probable cause on that. There is a capias attached with a $500 bond for a petty theft charge.
Yes, Judge, and just so that I have the notice to appear in front of me, Judge. It's a petty theft of pet items from Walmart, which were recovered. This was back in December of last year. Mr. Thomas would like to resolve that case so that he could squarely focus on the felony matter, if the court is so inclined.
Does Mr. Thomas have prior history?
Your Honor, yes, he does. And just to let the court know, on the felony cases, I'm asking that the court keep the bonds in place. From what I can tell, Mr. Thomas has 3 other pending felony cases, and it looks like he was arrested September 28th on a misdemeanor charge that is still pending.
Okay,
But
it's
he does
not,
have
and not
prior-
this municipal ordinance, but another misdemeanor case.
A state charge, yes. And in addition to that, he has prior felony convictions that he's gone to state prison on habitual offender sentences.
Okay, Mr. McLaurin, since nobody's here from the city, I'm going to leave the bond in the amount of $500 with a capias that was previously issued on this municipal ordinance case.
Okay.
Judge,
Have you
and
been
speaking with
appointed?
Mr.
Have you been appointed to represent him?
Yes, Judge, I have.
Okay. I'm sorry. Go ahead.
If I may, relating to the state offenses on the second look docket,
Yes.
I believe they're third-degree felonies, $2,000 the total bond. Mr. Thomas advised me he cannot afford that. He does have family that live locally in Fort Lauderdale, specifically his brother that would allow him to reside with him. Judge, he's just asked to request your honor if you would consider pretrial release because financially he can't afford to post a bond.
The state advised me Mr. Thomas has another case other than the one that's on the second look, so I'm going to deny the request to reduce the bond on that.
Yes, Judge.
Yes, he's a...
Next, we have Jacques Jean Baptiste.
North Broward, I believe.
North Broward, Your Honor, Mr. Jean Baptiste was in courtroom 6155 earlier. He hadn't made it back to the facility yet.
Okay. So you want to reset it for tomorrow? Okay, we'll reset then for tomorrow, which would be October the 12th. Am I getting those to you okay? Okay. Just let me know if I can help. Jacob Thomas Makowski.
Bonded, Judge?
Okay. Okay, he bonded. I do find probable cause. Gary Lee Lamb.
I've been advised he's a medical reset, Judge.
Okay. Would we like to set that for tomorrow on a medical reset? Okay.
Yes, Judge. It'll be reset for tomorrow morning, Judge?
Yes.
Okay, thank you.
Lamont Robert Scott.
Bonded, Judge?
Okay. I do see an out-of-county hold. Was that bonded as well?
I'm checking.
It does show there was a $5,000 bond on that.
I'm not certain.
Okay. You're certain he's not in custody, counsel? Okay.
I'm being advised, but he's released.
All right, I find probable cause as to the possession of cannabis, and then I will sign the probable cause sheet. Deshaun Doral Walker.
Medical reset, Judge.
Pardon me? Okay. Medical reset for tomorrow. Francisco Enrique Fernandez.
Bonded.
Do find probable cause as to carrying a concealed firearm and as to possession of cannabis. Dominique Alexander Neal.
Mr. Neal has family present, Your Honor.
Okay, if you'd like to come forward, you may. If you step right over here, then he'll be able to see you. Hi, good afternoon. If you wouldn't mind telling me your names, because everything's being recorded in this courtroom, so I'll start with the young lady. Pardon? Okay, and you, sir?
Anthony Howard.
Thank you for being here. How are you related?
I'm his auntie.
Okay.
I'm his step-uncle.
Okay. Mr. Neal is here this afternoon charged with possession of fentanyl. Bond in that is set in the amount of $1,000. I do find probable cause as to that charge. It's also here on a violation of probation. In that case, there is no bond. It does look like, though, there is a hearing scheduled in Division FH, which would be Judge Tim Bailey, and that's scheduled for the 12th at 8:30 in the morning on the violation of probation case. So I do find probable cause as to the possession of fentanyl case, and he does have a court date on October 12th at 8:30 in front of Judge Bailey. Okay?
Yes, ma'am.
All right.
Thank you.
Thank you, Judge.
Patrick William Lawson.
Judge, I've been advised bonded.
Do you find probable cause as to possession of THC, possession of cannabis over 20 grams, and possession of cocaine? Christopher Devon Tucker.
He's here at Maine, Judge.
Good afternoon, Mr. Tucker. You're charged with possession of methamphetamine, possession of gamma detox, GHB, drug paraphernalia, and 3 citations. Yes. His bond has been posted. You might want to let him know that. I do find probable
That's what we
cause.
thought.
Thank you very much. I do find probable cause as to those offenses. So, Mr. Tucker, you'll need to follow up with these charges, okay? Frank Antonio Miles.
Refused, Your Honor.
Pardon?
Refused to attend.
I'm familiar with Mr. Miles. He's actually got a case pending in my division, and he has apparently been refusing on a regular basis. He does have some issues that we've transferred the case to Judge Lerner Wren, but this looks to be a felony case, so.
Your Honor, if I can have one moment, because
Okay.
I could have sworn.
He was released, and this was a rearrest on a new case.
Okay, yeah, I guess we'll just have to reset it.
Would it help if I did an order, or?
They'll abide by whatever you say.
I just,
Force or whatever.
just if he, I don't want him to use any force, but just whatever reasonable means, if they could get him to come to court, I think if maybe someone could talk to him from your office,
No, maybe.
maybe you
Every
could.
reasonable means is sometimes up for debate as to exactly.
I'm not gonna write an order today, but I'm gonna reset it for tomorrow, and
Okay.
just want you to keep your eye on it. I am familiar with, there are some matters you might wanna look into. You do? Okay, no problem. We're gonna take a short break. We do have an interpreter here. Is that for a particular case?
Spanish interpreter?
Yes, we do have an interpreter
We have
here.
a gentleman here that requires a Spanish interpreter. He is on your second look docket. His
Okay.
name is Carlos Medina Santiago.
Okay, sir, if you would, please raise your right hand. Do you swear to translate from English to Spanish and Spanish to English the best of your ability?
Yes, I do, Your Honor. Theodore Leal for the record.
Thank you. Mr. Carlos Santiago Medina,
Son Carlos Santiago Medina.
you're here today, this afternoon, for what's called a second look at your case. Have you had a chance to speak to the attorney there with you?
Para lo que se llama una segunda vista. ¿Tuvo chance de hablar con el abogado?
Yeah. Sí.
Yes.
Okay. What would you like to tell me with regard to the second look? It looks like the bond was set for $1,000 plus electronic monitor on count one, giving false name, count two, $1,000 plus an electronic monitor, and count three, perjury in an official proceeding, $100 plus electronic monitor. Is that right?
Entonces,
Correct,
según lo
Judge.
que-
I believe
información
he's
que-
being.
Wait, he needs to translate that, sorry.
Entonces, era el pago, se había gestionado la fianza, era $1,000 más el monitor, el cargo por dar falso nombre, el cargo de perjurio o mentir bajo juramento, esos son otros $100 más con el monitor electrónico. ¿Así lo entendió?
Okay. Let me hear from you, if you wouldn't mind, counsel.
Abogado.
Judge, he has a total of 2,100 with Elmo, as Your Honor stated, but unfortunately, the problem is going to be the Elmo.
What's the problem?
I'll let him translate.
A
Okay.
ver, sí, lo que pasa es que tenemos todavía el problema. Habían puesto la fianza de $2,000. Counsel, what was the last thing you said?
The problem is that when we use Elmo, that's not a good translation. So electronic monitoring device.
Electronic monitor system.
Thank you. Sí, para la cuestión del monitor electrónico. Ese es el Elmo.
So as you know, Judge, you have to actually verify where he's going to reside.
Porque tiene que verificar dónde va él a residir.
Yes.
He was residing in Hialeah, but unfortunately, he informed me right now, that residence is no longer available to him.
Porque él estaba viviendo en Hialeah, pero según le informó, esa residencia ya desafortunadamente no va a estar disponible para usted.
So does he have a place to go?
¿Tiene dónde ir?
No, he does not.
Okay.
No tiene, no
The
tiene dónde ir.
monetary fund, Judge, he finally, last time he was here, I believe we entered a phone order. He was given access to his phone, so he was able to contact family who resides, specifically, I believe his who resides in California, that he's going to reach out to help post a monetary bond. So I think that problem will be solved.
Entonces, la última vez que él estuvo acá, creo que se le dio esa gestión para tener el contacto telefónico. Iba a contactar a la familia de California, para que entonces, mediante eso, la familia de California pudieron hablar sobre la cuestión de la fianza monetaria.
Let me hear from the state.
Aquí dice la fiscalía.
Your Honor,
Señoría.
I do believe the GPS monitor or electronic monitor that was ordered by Judge Malika is not only appropriate in this case, but necessary.
Yo creo, su señoría, que el GPS o el monitor electrónico que la juez Mónica ordenó era no solamente apropiado, pero también necesario.
Your Honor, we can provide you a copy of the probable cause affidavit.
Le podemos dar la copia a su
I would
señoría
appreciate
de la
that.
de indicio de culpa. Yo se lo agradecería.
But the issue is,
El problema es que
we don't know who this person is.
no sabemos quién es esta persona.
And I think once Your Honor has an opportunity to read the affidavit, you'll see why I say that.
Y cuando su señoría tenga la oportunidad de leer esta affidavit, va a ver su señoría por qué es que estoy diciendo esto.
Okay, I have reviewed the probable cause affidavit, and I do understand the request or the order by Judge Malika that if in fact he does post a monetary bond, that he would be supervised on an electronic monitor, particularly in light of the allegations in the probable cause affidavit.
Electrónico, tomando en cuenta las alegaciones que hay en el affidavit de indicio de culpas.
So I'm going to deny your request to delete the electronic monitor at this time.
A esta altura, entonces le voy a negar su
I lost
requerimiento
there.
de monitor electrónico, que quite el monitor electrónico.
So this order says to reduce. No.
And you're not removing the alcohol?
No.
So it's no
So I didn't think I need to do an order. Okay. Okay, so we're back to Richard Henry.
Hector, did you have anyone else?
Oh, sorry, I'm sorry.
As far as Spanish interpreter, no, Judge.
Okay,
¿Alguien habla español? No, no one else, Judge.
okay. Thank you very much for helping. Appreciate it.
I don't know if the other facilities, Judge, though. Like
Okay, hang on, let me just check. Anybody at Paul Ryan need an interpreter?
I think that's safe.
No, Your Honor.
Anybody at Conti need an interpreter?
No, ma'am.
Anybody at North Broward need an interpreter?
Oh, man, we're good, Your Honor.
Thank you. Thank you very much. Okay, we're back to the main jail. Richard Henry.
Judge, I've been advised he's in regular courtroom 7900.
On this case?
Yes.
I don't know. The deputy just advised me he was in court, so they couldn't bring him here.
Your Honor, I was looking at the order that Judge Bailey signed yesterday, taking into custody, and on it he wrote to have the arraignment and bond status set for today at 8:30, so they might not have gotten it back yet. We can reset them for tomorrow morning.
Okay. I have Roman Zenin.
He's here present, Judge. He's approaching at Maine. But my understanding, he's represented by, I believe, regional counsel.
He is represented by regional counsel, and I'm not sure the reason for the case being on. Wasn't there a previous finding of probable cause?
There was, Your Honor. He was arrested. He was arrested on an arrest warrant for second-degree murder. The state filed a charge of manslaughter. Because of the bond schedule, it reattaches the no bond hold for magistrate, so they bring him back to first appearance.
Okay, but there was previously a bond set.
There was a previous bond set. On the original arrest warrant, bond was set. I don't remember what judge signed the warrant, but bond was set at $500,000. Judge Benson presided over the first appearance and kept the bond at $500,000. The court is inclined. I can tell you, he's being arraigned, I believe, next Tuesday.
Okay.
And based on the nature of the offense, I would ask that the court just place the $500,000 balance back on it.
Okay, so my understanding here today, he's charged. He's here on the manslaughter charge that was filed by the state, and I do find probable cause as to that charge. The bond amount was previously set on a warrant in the amount, it looks like to me, $200,000.
I'll check again.
And he is represented by counsel.
My vision, I might have had it wrong. Let me just check again real quick. You know, that's correct. Your Honor.
Okay.
It was the writing on the findings.
So I do find probable cause as to the charge of manslaughter in this case, and the bond will remain in the amount of $200,000, which was previously set, and you'll be able to talk to your attorney about that. Okay, sir?
Sorry.
Thank you, ma'am. I mean.
Yes, you. Miguel Forrest.
Conti, Your Honor.
Miguel Forrest.
Yes.
Good afternoon, sir. You're here this afternoon charged with fleeing and eluding a police officer at a high speed and attempted burglary of a dwelling. It looks like those change of charges.
Yes, Your Honor, if I may, the fleeing and eluding is really a technical change of charge. Bond was originally set at $1,000. I'm asking that it be placed back at $1,000. The burglary is another technicality. I reviewed the original findings, and it looks like he was booked or charged incorrectly for burglary of a structure. Judge Malika actually found probable cause for burglary of an attempted dwelling, which is what we charged.
So probable cause has previously been found as to each of these?
Yes, Your Honor. Bond on the burglary was set at $7,500, and since Judge Malika found probable cause for the charge he stands before the court on, I'd request that you place the $7,500 bond back on him.
Okay, having there been a previous finding, unless you want to hear from you, Mr. Reedy?
Mr. Forrest has some other bonds pending on some other charges as well, Judge. I think he probably needs to go in front of his division judge.
Okay.
And reduce everything.
Mr. Forrest, these are just technical changes in the charges. The bond is going to stay the same amount that it was, which is $1,000 on fleeing, eluding, and $7,500 on the attempted burglary, okay? There's been a previous... Now I have Servio Manuel Espalit Alvarez.
He's here, present, Judge. He informed us he has private counsel, Mr. Elliot Perez, and he did give me a phone number, Judge.
Okay.
The phone number is 954-854-0211.
Is he requesting that I call counsel?
I believe so, Judge, yes, please.
Can you tell me his name again?
Elliot Perez.
Good afternoon.
Mr. Elliot Perez, please. This is Judge Carpenter Toy calling. You're on speaker. You're on speakerphone in open court.
Okay, Judge. Good afternoon.
Good afternoon. I do have before me this afternoon Servio Manuel Espalit Alvarez here on a robbery with weapon charge, and he has advised us that you are his attorney of record in this matter.
That's accurate, Judge. We were actually in court with him yesterday.
Okay.
I had no notice of this afternoon's court hearing or the reason why it might be set before you.
Maybe the state can enlighten us on why it's set for today.
Yes, Your Honor. What happened was the state...
Can you hear him?
Yes, I can, Your
Okay.
Honor. Thank you.
The state upfiled the charge from aggravated assault to robbery with a weapon. That in turn created a change of charge KPS. When a change of charge KPS is created in this instance, even though a bond was previously set, based on the bond schedule, robbery with a weapon has a no bond hold for magistrates, and the KPS resets the bond at no bond hold for magistrates. The clerk's office has to proceed to get the KPS paperwork to the jail, who resets them for another first appearance to have the bond set.
Okay.
It just so happened that process, it finished after he'd been arraigned.
Okay, so it looks like he's here on a robbery with a weapon charge, and the capias that was issued is a no bond capias. Was there a bond previously set?
There was, Your Honor. When it was an aggravated assault, Judge Murphy heard the first appearance and set his bond at $3,500. Your Honor, even though it's been upfiled to a first-degree felony at this time, I'm going to request that the court place the $3,500 bond back on him, noting that he has a no bond hold on a violation of probation, felony violation of probation anyways.
Okay, counsel, you wish to be heard. The state's requesting that I
Judge,
set the bond at 3,500 as it was previously set.
Unless his judge
that's
addressed it.
absolutely fine, Judge.
Okay, so I'm going to find probable cause as to the new charge. I am going to set bond in the amount of $3,500 on this charge. And Mr. Alvarez, you can be in touch with your attorney, okay?
Yes, ma'am. Do you know when I would have to go to court?
I show that this case has there's some hearing scheduled for the 12th, which will be tomorrow.
Judge, I actually arraigned him yesterday,
Okay,
so that 12th in front of Judge Duffy has been deleted.
except for that did you arraign him on the new charge?
Yes, correct.
Okay.
As filed with the amended information.
Okay, so you be in touch with your attorney about when your next court date is. Thank you, counsel.
Thank you, Your Honor. Have a nice day.
So I have a couple of photograph orders on some people here being requested on these orders that were previously granted.
I don't believe the state has any objection, Judge. There are people from previous dockets, somebody
Okay.
has to see him in the jail, realizes, hey, we need some pictures taken.
Yeah, no, I have no objection.
State having no objection, I'll sign the orders. Sure.
It's on the second look docket. It's Corey Levy. He's in the main jail.
Mr. Levy?
Mr. Levy?
Mr. Levy, you're here this afternoon for us to take a look at your cases that you're being held on. Mr. McLawrence is here. Can you see him?
Yes, ma'am.
Mr. McLawrence, you represent him on the 2 trespass cases?
Yes, Judge.
Okay.
I just spoke with him too.
And does Public Defender's Office represent him on the other charges?
On the state offense is correct, Judge.
Okay. I'll hear from you, Mr. McLawrence.
Judge, Mr. Levy did indicate to me that he does have an address where he could go to, and that he's going to be actively seeking to get placed into BARC IRT. So on the felony matter, Judge, although he's represented by the state, what he wanted to ask the court is if the court would place him on pretrial release, and I do have that address. And as far as the municipal ordinance is concerned, Judge, he would like to resolve I think it's 2 municipal ordinances, and he would like to resolve them, but I also think I saw a state misdemeanor trespass, if I'm not mistaken.
There is a felony possession of heroin. There is a misdemeanor possession of drug paraphernalia, which also includes a trespass charge. And then there are the 2 municipal ordinance violations. Let me hear from the state.
Your Honor, I'm just checking on the misdemeanor. Okay. If he,
Are these capiouses?
They are.
Okay.
They are. Do we know, does he have and I apologize to Mr. McLawrence if you already stated this, does he have an address?
Well, that's what Mr. McLawrence is saying, but he also says he wants to go to BARC IRT.
I can put their address on the record.
That's okay, you don't need to do that, I don't think, do you? I could
No,
do a change of address, because when the change of address is just noted on the magistrate's paperwork, the clerk's office doesn't change the address. So there needs to be a change of address form actually filed in order for that to happen.
I don't have a problem with pretrial on the felony, and if he's looking to resolve the state misdemeanors, I do have an offer to be an adjudication time served on each count.
And Judge, in reference to the misdemeanor state offenses, and speaking of Mr. Levy, that is exactly what he wanted to do. He wants to try and resolve that matter. Financially, as you can see, he can't afford to postpone. He did tell us as far as he's going to be living in Cold Spring with his family. So we'd be asking for him to be released on pretrial release on the possession of heroin offense.
The 2 the municipal ordinance violations, do you have dispos on all these? Yes, Your Honor. You do? Okay, so if he'd like to enter a plea to the misdemeanor charges, how many days does he have in?
I know he's been in custody since the 8th. I don't know when he was first arrested on the charge. I don't know.
And is he offered from the state an adjudication or withheld?
He is prior to being adjudication.
Okay, he's been previously adjudicated?
Yes, ma'am.
Okay. If you, we need to know how many days he has in order for me to.
Judge, I also have that he came in on the 8th.
Okay, so if he wants to resolve the misdemeanor charges today, I will adjudicate him guilty, sentence him to 3 days in the Broward County Jail, credit for 3 days time served. On the possession of heroin, I would enter an order releasing him to pretrial release with the special condition of pretrial release that he report to BARC within 24 hours of his release. Failure to do so would be a violation of his pretrial release.
What if they don't have
Talk to your attorney.
What if they don't have a bed available?
I said
he just has to just go there.
he has to go there, and he has to continue to go there as they instruct him to until he gets a bed.
Mr. Levy, are you paying attention? Mr. Levy? Did you hear what
Yes,
the
I
judge said?
understand now.
So you need to go
Yes, I
there and go
understand.
there and go there and go there and show some type of proof that you're going there to pretrial release. Otherwise, they'll violate you and you'll be
Sure.
back in front of
As far as
back in
him
custody.
going, as far as him going every day, most likely he's going to go through the interview process, and there's probably about a 30-day wait on a bed. If they tell him there's a 30-day wait, I don't think the court wants him to go every single day and say, "How's the bed coming along?" Right?
I want him to do whatever BARC tells him to do.
Perfect. So if they said they'll get his contact information,
I don't want him to report to BARC and then say, "I'll see you in 30 days." That's not going to be sufficient. So he needs, otherwise I'll put a monitor on him. That's up to him. If he wants to be released, pretrial release, then he's going to need to report to BARC within 24 hours, and he's going to need to tell them that he needs to see them on even if they don't have a bed for him, he needs to be involved in a daily outpatient until they get a bed for him.
Yes, ma'am, I can agree with that.
I just want to let you know, Judge, when he was originally arrested on the state misdemeanor charges, he was arrested August 1st and was ROR released August 2nd.
Okay. All right, is that what he wants to do?
Yes, Judge.
Mr. McLawrence?
Yes, Your Honor.
Okay. All right, Mr. Levy? Mr. Levy, do you need some more time to talk to your attorney before you make this decision?
He has one question for me, Judge, and I'm going to answer for him.
Okay.
So he's only going on pretrial supervision on felony.
Yes, with the special condition that he report to BARC within 24 hours.
He understands, Judge. He has no more questions.
Thank you. Yes, thank you.
And Judge, you will report to pretrial within 24 hours of his release?
Yes.
Okay.
Okay, Mr. Levy, then on the possession of heroin charge, you're going to be released to pretrial release, which means you're going to need to report to them within 24 hours. As a condition of that release to pretrial release, you're going to be required to report to BARC and sign up and be evaluated by them within 24 hours as well. You understand?
Yes, Your Honor.
You're also charged with possession of drug paraphernalia and trespass on a property. Is that charged as a first-degree trespass?
I'll check, Judge.
And do you know on the municipal ordinances, Mr. McLawrence?
Municipal ordinances are typically filed as second-degree misdemeanors, Judge.
You know specifically in these cases or not?
Both state misdemeanors were first degrees.
Okay. And do you have any paperwork with regard to the municipal ordinances?
All I have is I have the complaint affidavits in both cases, Judge, and there's no indicate. It just cites the general statute, which is 16-1, so it doesn't break it down to tell you if it's a first or second degree.
Mr. Levy, you're charged with possession of drug paraphernalia and possession or trespass on a property. Each of those are first-degree misdemeanors, punishable by a maximum of 1 year in the county jail. You're also charged with 2 separate municipal ordinance violations from the city of Fort Lauderdale, where the charge is trespass. Those are also first-degree misdemeanors. If you'd like to enter a plea to those today, your attorneys have told me that that's what you want to do. Is that what you want to do?
Yes, Your Honor.
And you had an opportunity to speak to both your attorney on the state case and your attorney, Mr. McLawrence, on the two city cases?
Yes, they've both been very helpful, Your Honor.
Okay, and so before I can accept a plea, I need to ask you a couple of questions. Are you under the influence of any alcohol or drugs here this afternoon?
No, Your Honor.
Have you ever been treated for a mental illness?
No, Your Honor.
You currently taking any medication?
No.
Okay. If you're not a United States citizen, entering into this plea could subject you to deportation and/or a change in your immigration status. You understand that?
Yes, Your Honor.
Knowing all that, you wish to enter a plea to 3 counts of trespass and 1 count of possession of drug paraphernalia.
Yes, Your Honor.
The parties stipulate to a factual basis as to each case?
Yes, Your Honor.
Yes, Judge.
I'll accept that. Go ahead, sir.
For purposes of the plea, yes.
Sorry, I didn't mean to cut you off. I'll accept that stipulation, and as to the case number 188228MM10A, I'm going to adjudicate you guilty of possession of drug paraphernalia and trespass on property. Sentence you to 2 days in the Broward County Jail, and give you credit for 2 days' time served. As to case number 188528MO10A, I'm going to adjudicate you guilty, sentence you to 2 days in the Broward County Jail, and give you credit for 2 days' time served. And on case number 188335MO10A, I'm going to adjudicate you guilty and sentence you to 2 days in the Broward County Jail, 2 days' time served. Each of those cases also comes with it court costs in the amount of $293.
Judge, if I may, with the municipal ordinance cases,
200 and
when we resolve at magistrate's court, the court cost that we assess is $78 for the municipal
78?
ordinance. Yes, Judge.
$78 on each of the 2 municipal ordinance violation cases. I'll give you 1 year to pay the court costs in these cases. Okay, sir? Now, good luck to you.
Oh, Judge, just one more thing I want to tell Mr. Levy. Remember, there may be another municipal ordinance out there that's unfiled, so you need to stay in touch with me so you don't miss that court date.
I have your card, Mr. McLawrence.
Okay, then. Take care.
Okay.
All right, thank you.
Good luck, sir.
Next we have Jason Joseph Gillis.
Conti, Your Honor.
Are you Jason Joseph Gillis?
Yes, ma'am.
Good afternoon, sir.
Good afternoon.
You're here charged, actually, that's a capias on 2 felony. Are these ad charges?
They are.
There are counts 2 and 3. One is possession of ketamine and the other is possession of fentanyl. I do find that there is a capias that has been issued, so probable cause, I do find probable cause, and each of them have a $1,000 bond.
Yes, ma'am.
Okay.
Your Honor, Mr. Gillis has $50,000 in bonds on other charges, so I'm just asking that the court keep these bonds.
That is correct, Judge.
We'll leave the bonds where they are then.
He needs to go in front of his division judge. to address
Okay.
those issues.
You need to see the judge that's handling your case if you want to address the bonds, okay?
Yes, ma'am.
Okay. And I have Kevin Andre Mesa.
North Broward.
North. Yeah, Your Honor, this is up for perfection. It had to do with the original probable cause affidavit does not list a dollar amount of the damage. I spoke with Deputy Mendez yesterday. Unfortunately, he was on his way out of town with his family, and I haven't, the reports he submitted haven't gotten into the system at record yet. So there's nothing for me to present the court as far as felony criminal mischief. I would ask the court to make a finding of probable cause for misdemeanor criminal mischief.
Okay, it looks like that was done yesterday.
Okay, well.
Probable cause for a misdemeanor and a $500 bond was set.
Yes, there was a $500 bond set, as far as the felony criminal mischief. Your Honor, the issue is, and I can tell you, we spent quite a good amount of time on Mr. Mesa's case. The concern that Judge Malika had was, frankly, Mr. Mesa was making some comments yesterday that caused her to have, and I think it's fair to say, to speak for her, that caused her to have really great concerns for his mental health. And we were trying to figure out, you know, a resolution for release conditions that didn't involve him being in custody, but it was really based on the type of statements he was making. And I'll just tell you, He was making references to zombies, aliens, that Jurassic Park will be back in 4 years. And I don't think he meant necessarily that the movie will be back in 4 years.
Was that yesterday at the magistrate's hearing?
It was at the first appearance hearing, Your Honor.
Okay.
I can tell you, I did, because obviously you can't go to Judge Lerner right at this point in time because it's a felony charge. I can advise you, and this isn't a situation where the officer put the, mistakenly charged it as felony when he meant less than $1,000. He did advise me the information he received was that the damage was over $1,000.
Okay. What says you, Mr. Reedy?
Well, we haven't seen anything to that effect, Judge. You could find criminal mischief, misdemeanor criminal mischief, and send them to Judge Lerner.
Well, it looks like that's already been done, is what I'm telling you. It looks like yesterday, Judge Malika found probable cause for a misdemeanor and set bond in the amount of $500.
Which Mr. Mesa is never going to be able to make. He's homeless and has been homeless for an extended period of time.
And Your Honor, he can't be transferred to Judge Lerner because even if you find PC for a misdemeanor, it's still, until another charge is filed, it's a felony case. And that's why I was bringing up the fact...
The case number's a felony case.
Yes. And that's why I was bringing up the fact that this isn't a situation where the officer accidentally put in the wrong statute number.
No, I understand. But since there is nothing before me here today with regard to the amount, then I do believe that there's probable cause for a misdemeanor at this time.
No argument.
And that I'll leave bond in the amount of $500 at this time.
And Your Honor, I don't have an objection, and I don't know if it's going to make a difference, but the standard bond for a misdemeanor criminal mischief is $100.
Yeah, it might make a difference because I'm going to call his grandparents to see if they can bond him out. So I think a $100 bond would be appropriate.
I have no objection to that.
Okay. Okay, Mr. Mesa, I do find that there's probable cause in your case for a misdemeanor, and I am reducing the bond to $100. Mr. Reedy, who's here in the courtroom, has indicated he's going to try to be in touch with your family to see if they can assist you. Okay?
Thank you.
Okay.
God bless you. Thank you. Yeah, she got it. Come on.
Okay, it looks like we have some people in the main jail. So what, just go through the second look docket? Oh, we do have a recall. See if we have Mr. Joseph. Mr. Joseph at North Broward? Is it Mr. Joseph?
Yes. No. That was the one that was in transit. She never got here.
Oh, she's still not there.
She has a no bond hold, Judge.
Okay, so just reset it for tomorrow? All right, we're going to reset that for tomorrow. Okay, then we'll look at the second look docket. You want to tell me who's there with you?
Yes, Judge. The two gentlemen that are left here at Maine on the second look docket, first person is going to be coming on up, sir. Mr. Addison Jones, Judge.
Okay, Mr. Jones is charged by way of a felony charge of resisting an officer with violence and touch or strike battery, 2 counts. And it looks like the bond currently sits at $1,000 and PTS, pretrial services.
Bond plus pretrial with special conditions of that he obtain the psychological evaluation, follow all recommendations. Obviously, no victim contact, no firearms, weapons, or ammunition.
Okay. And
Judge, at this time I spoke with Mr. Jones. He gave me the phone number of his family member. I got off the phone with his family. She advised us that basically she's going to be posting his bond tomorrow. So at this time, I'd ask you not to take any action on this case.
okay, we're going to take no action, and then the bond will stay as it is at $1,000 plus pretrial. And the other person that's there with you?
The last gentleman here, Judge, is Mr. David Terenzi Vivian.
Okay, good afternoon. Mr. Teresi Vivian looks to be charged with reckless driving and a first-degree misdemeanor with a $100 bond.
That is correct, Judge. Also, there are two other matters holding him. One is another petty theft in which he has a $100 bond when I checked DSO pics earlier today during lunch. And he is currently awaiting placement at the Bark IRT, in which he's just waiting for bed space. So I'd ask you at this time, Judge, to consider so that there are no holdups when space becomes available. On this reckless driving and speeding, Mr. Teresi, he wishes to resolve that matter. And also on the petty theft, which is currently holding him on a $100 bond, he wishes to resolve both matters. Now, on the petty theft, my understanding, it allegedly took place at a Publix where the merchandise was recovered, so there are no outstanding restitution issues. So I'd ask the court to consider resolving both the reckless and the petty theft.
Well, we have to have the case number of the petty theft.
My colleague, Mr. Reedy, or Mr. Lender, could look that up.
Your Honor, I can look it up, but while I'm doing that, I can tell you I don't have an offer as far as the reckless driving. I don't know that that's really an appropriate charge. But that being said, I don't have an objection to an ROR in the reckless driving. I don't have an objection to an ROR in the theft because I don't want to see.
Why do they go away?
It should come right back.
Judge, and I understand if that's one of the things we've discussed. The state might not have an offer on the reckless, and if that's the case, Judge, then we'd be asking for an ROR.
Let me ask you a question. Has he been sentenced to the IRT?
I don't know. When I saw BSOP, it just said awaiting placement at IRT with no monetary component. Just
It would show a case number if that in fact.
Yeah.
Was that done?
Yeah, I don't know that it's a sentence. It might just be a pretrial release.
Well, I'd like to know who. I mean, is it a felony case? Is it a felony drug case?
It's a possession of cocaine.
Is it a drug court case?
I'll check that right now.
Judge, also, he just added more information. My understanding, one of the conditions before Bark IRT, before he can be placed, he says he was ordered to complete the SAP program.
So is he doing SAP now?
Placement. No, he's awaiting placement. So it's going to be a while. So maybe I'm not going to ask you to ROR him on the reckless because I want him to receive all his gain time. So I'd ask you maybe to a $1 bond on the reckless and $1 bond on the petty theft.
Your Honor, he'll have, from what I'm hearing, he'll have plenty of time to see his division judges before he's done with SAP. I just asked the court to leave the bonds in place.
I'm not going to take any action on these. If he's got to do SAP anyway, while he's there, he can try to take care of the reckless driving and the petty theft. Okay,
Thank you, Judge.
So I'm going to take no action on this.
Thank you. Judge, it's been a pleasure. We have nobody else at me.
All right.
Thank you.
Is there anybody else at any of the other facilities?
No problem, John.
On the other case number? No, we didn't. Okay, the case, hang on a second. The case number on Teresi is case number 1828273TC10A. I took no action on that. Sorry, Mr. McLawrence, I'm just getting to you.
You want to deal with Humphrey first since he's not there? You want to deal with Humphrey first since he's not there?
All right. Okay, we're at North Broward. Who are we looking for there?
Your Honor, the first case, I don't believe he is there. Frank Humphrey, I've been advised he refused. I discussed this with Mr. Reedy. I don't know if Mr. Reedy has an objection. I am suggesting the court consider transferring the case to Judge Lerner Wren. This is now 2 afternoons in a row.
Which case is it?
Frank Humphrey.
Okay, I
believe he's there. I believe he's there. I think he just refused. Or is he?
Do we have at North Broward? Do we have Frank Humphrey?
He did refuse to come, Your Honor.
Okay.
So it's 2 afternoons in a row that he's refused, Your Honor. I did check and I advised Mr. Reedy. In the past, on at least a couple cases, he has gone before Judge Lerner Wren.
Okay, so we can transfer Frank Humphrey to Judge Lerner Wren?
Yes.
Okay, so we do a transfer order, do you have that?
Clerk should.
Yeah.
Madam Clerk, do you have a transfer order for Judge Leonard Wren's MI division?
Okay, if we could transfer Frank Humphrey. We're going to transfer that case to Judge Lerner Wren based on the representation of both counsel for the state and counsel for the defense. All right, who else do we have?
This is Dominique Alexander.
I'd like to resolve this case. The state's offer is an adjudication time served.
That is correct, Judge.
Okay. Miss, is it,
Dominique Alexandra.
your last name is Alexander?
My last name is Dominique.
Okay. Miss Dominique, you're here today. You're charged with trespass of an occupied structure or conveyance. That's a first-degree misdemeanor.
Yes.
Punishable by a maximum of 1 year in the county jail. You understand?
Yes, ma'am.
You have an attorney here in the courtroom, Mr. Reedy. Have you had a chance to speak to him?
Probably over the phone earlier, but not.
Yes, we spoke on the phone.
Did you speak to him on the phone earlier today?
Yes, yes.
And did you have enough time to speak to him?
Yes.
And do you need any more time to speak to him?
No, I don't need it. I understood everything, ma'am.
Okay, what I need to do before I take a plea from you is ask you a few questions.
Yes.
The first question is, are you under, well, first do me a favor and raise your right hand.
Yes.
Do you swear or affirm to tell me the truth?
Yes.
You can put your hand down.
Yes.
You can put your hand down and then state your full legal name for me.
It's Alexandra Dominique.
Okay. As I told you what you're charged with, I got to ask you a few questions before I can accept a plea from you, okay?
Yes.
The first question is, are you under the influence of any alcohol or drugs here today?
No, I am not.
Have you ever been treated for a mental illness?
No.
Okay.
I have that.
You understand, by entering this plea here today, if you're not a United States citizen, it could affect your immigration status, including deportation and or a change in your status. You understand?
Yes, I'm aware of that.
Knowing that, you still wish to go forward and enter the plea today to the charge of trespass.
Yes.
And the recommendation is that I adjudicate you guilty of trespassing, sentence you to how much? How many? Do you know how many days?
She was arrested on
October 6th?
Yes, ma'am.
Yeah.
I'm going to sentence you to 5 days in the county jail and give you credit for 5 days time served.
Yes. Yes, ma'am.
How would you like to plead? Guilty or no contest?
Well, I'm getting time served, so I don't know. That's up to my what's best for me.
It won't matter either way.
It's up to you. You can plead guilty or no contest.
No contest, I guess.
Okay, I'll accept your plea. I'll find that you're alert and that you understand what you're doing, and you're entering into this plea with the advice of a competent attorney, Mr. Reedy, with whom you've told me you're satisfied. I'm going to adjudicate you guilty of trespassing.
Yes.
Sentence you to 5 days in the Broward County Jail.
Okay.
And give you credit for 5 days time served. I also impose $293 in court costs. I'm going to give you 1 year to pay those court costs, okay?
Okay.
All right, good luck to you, ma'am.
Thank you.
How about Sabrina King?
So,
we have Sabrina King anywhere? It's on this docket.
I'm showing she's been released, Your Honor.
Oh, you are? Okay, thank you. Do you have anyone there we need to see, or that's it?
No, I don't have anyone here, but I do have 3 more on the docket. But one didn't want, Villainous, Marianne didn't want to come.
Yeah, that was resolved yesterday.
Okay, apparently they took care of that yesterday.
Okay, Guerrero Herlin, he was in downtown courtroom 6170.
I went to Judge Moran.
Okay, we took care of that too.
And O'Brien John is he's another one that just doesn't want to come. We can't get him down here.
That's a municipal ordinance, I believe. I'll check, but I could have sworn that was going to Judge Lerner. That one, he went to Judge Lerner also.
Okay, that's been transferred to Judge Lerner. Thank you very much.
Okay, thank you.
Okay, are there any other matters? Okay, so we'll be in recess.
Thank you, Judge. I'd love to stay in chair.